video presented, Just Talking. Please note there will not be a decision issued today. It is also important to note that the goal of today's proceedings is to persuade a majority of the justices, namely 5 out of the 9, to vote in favor of reversing the district's dismissal and permitting the commencement of discovery. We have never been this far, and this case deserves its day in court. With these procedural details in mind, we will now proceed with the presentation of arguments. In just a moment, Attorney Demario Solomon Simmons will begin his opening argument, followed by the presentation from the defendants. If you have any questions or plan to post to social media, please use the hashtag 1921WatchParty. Thank you for being with us today. Justice for Greenwood.
And with me at council table, I have William Flanagan, who is an Assistant Solicitor General. For the Tulsa Regional Chamber, I have John Tucker and Colin Tucker. For the City of Tulsa, I have Christina Gray. And for the Board of County Commissioners of Tulsa County and the Tulsa County Sheriff, I have Keith Wilkes.
Thank you, sir. All right, appellants will be allotted 25 minutes to present their case. During this time, justices may ask questions as points are presented. Mr. Solomon Simmons is now recognized.
Thank you, Mr. Chief Justice, and may it please the court. The district court should be reversed for 4 primary reasons. First, the survivor sufficiently pled a property-based claim for public nuisance under Oklahoma's notice pleading standard and the framework that was set out by this court in Johnson & Johnson in 2021. The survivors allege that defendants blighted the localized discrete Greenwood neighborhood through offensive and criminal acts causing property damage that is ongoing and requires abatement. And this court has held for over 113 years that blighted property can cause a public nuisance, and there is no statute of limitations on a public nuisance. Second, the district court's reasoning for dismissing the survivor's case because they, quote, failed to state a cognizable remedy is contrary to the well-established precedent of this court. At the pleading stage, quote, a plaintiff is not required to identify a specific theory of recovery, a remedy, or relief. Therefore, the district court's holding these plaintiffs to describe the exact abatement remedy before trial, before even discovery, is a heightened pleading standard that has no basis whatsoever in the pleading code or the precedent of this court. Additionally, the record actually shows that these plaintiffs did plead the equitable remedy of abatement, which has been allowed by this court to remediate blighted property since 1907. Third, this case is not about, quote unquote, eradicating racism or managing public policy matters or affairs, but adjudicating justiciable claims between parties. The survivor's public nuisance claims are justiciable because of a definite and concrete controversy between adverse parties, and the controversy is ripe for a decision by the district court. A decision to decide if the Greenwood neighborhood is still blighted and requires abatement, and if so, what would the abatement look like? Further, this court has stated that district courts have the original jurisdiction pursuant to the Oklahoma Constitution to hear these type of public nuisance cases, and pursuant to the public nuisance statutes, they actually have the duty to decide if a plaintiff is specifically injured pursuant to the public nuisance statute 50 OS 10. In fact, this court has stated that this duty applies to the district court even if other branches of government may have concurrent jurisdiction. And fourth, the survivors properly pled a claim for unjust enrichment under Oklahoma's notice pleading standard. And there's nothing in the record that explains how the defendants overcame the heavy burden of demonstrating that the survivors could prove no set of facts entitling them to relief at this stage of the pleading litigation. So court, today, the question before the court is very simple, straightforward, and procedural in nature. Did these survivors properly plead a public nuisance claim and an unjust enrichment claim pursuant to Oklahoma's liberal notice pleading standard? The answer is yes. That's why we want this court to reverse the trial court's decision and remand us back to start discovery as soon as possible, as time is of the essence for these two 109-year-old survivors who are here with us today. At this point, I'm going to talk more in depth about the 4 issues that I brought before the court, but I want to make it clear I am open and ready to answer any questions at any time. Just dive deeper into how we actually properly pled a public nuisance claim per this court's precedent. I'll first start with a case that the Chief Justice writing for the court last year called McGee versus El Patio LLC, where the Chief Justice reiterated the longstanding precedent of this court that, quote, a motion to dismiss for failure to state a claim upon which relief may be granted will not be sustained unless it appears without a doubt that the plaintiffs can prove no set of facts which would entitle the plaintiff to relief. So when you combine that with the roadmap that this court set out in Johnson & Johnson, where you told us, Justice Winchester, writing for the court, told us exactly what is a public nuisance here in Oklahoma. One, defendants creating crimes that constitutes a nuisance. Or two, the defendants causing physical injury to property or participating in offensive activity that renders property uninhabitable. And if this happens inside of a localized, discrete neighborhood, that constitutes a public nuisance here in Oklahoma per Johnson & Johnson. In our petition, which can be found on the record at document number 37, if you look at paragraphs 32 through 60, we lay out in great detail how these defendants committed crimes against the Greenwood community and these plaintiffs that are here today, and how these defendants destroyed property, and that property is uninhabitable to today. We specifically stated, pursuant to 50 OS 2, that this massacre occurred in the local discrete neighborhood of Greenwood. We also made it very clear that the defendants destroyed over 1,500 pieces of property, and we allege that many of those properties are still uninhabitable, still blighted, or still destroyed, or that the defendants still own the properties that they acquired because of the massacre. And we have alleged in our petition that those properties can be disgorged or given back to those rightful owners. So if this court, understanding its precedent to take all of our facts within our pleading as true, if it is true that the massacre created a public nuisance within the localized, discrete neighborhood of Greenwood because of crime and property damage, then we should be able to survive a motion to dismiss. I think at this point, it's important to understand our public nuisance claims, just like an oil and gas public nuisance claim. And we cited many cases in our briefs. One I would like to talk about is Manders versus Johnson, which is a Court of Civil Appeals case, which is obviously not binding on this court, but I think is very persuasive. Because in that case, you had a public nuisance that oil and gas exploration that actually started in the 1920s. And the case was not brought into the late 1990s and not resolved until 2006. And the court in Manders versus Johnson stated it does not matter when the actual pollution starts. And it's the same here. It does not matter that the massacre happened in 1921. What matters is that the public nuisance, the property is still blighted. There's still vacant properties. The public nuisance is ongoing, causing the Greenwood neighborhood to suffer its health, safety, comfort, and repose, or feel less secure in their life and security. That comes directly from the statute at 50 OS 1. We also cited a case called Briggs versus Freeport, McMorran Copper and Gold. This is a very interesting case because it involved a smelting plant in Blackwell, Oklahoma, that was in operation from 1916 and ceased operations in 1972. And yet a lawsuit by the plaintiffs were brought in 2015. And the Western District in that case allowed a motion to dismiss. They overruled a motion to dismiss based on the fact that the plaintiffs were able to say that the pollution, the public nuisance was ongoing. And that's where we are at this stage in this litigation. We haven't done any discovery. We haven't had opportunity to do any fact finding that we need to do for this case to move forward. And we believe if we had that opportunity, we could prove the allegations that we state in our petition. Next, I want to talk more about, the district court dismissed us specifically because she said we didn't plead an abatement remedy. Well, as this court has stated many times, a plaintiff is not required to have a specific remedy. And I would just cite Darrow versus Integris Health for that particular proposition. But I also point out to the court that pursuant to 50 OS 8 of the public nuisance statute, there are 3 particular remedies available for a public nuisance. 1, an indictment. We couldn't ask for that because we're not a state entity. 2, a civil action. That's a claim for monetary damages. We could not ask for that. 3, abatement, which is equitable relief, as Justice Winchester pointed out for the court in Johnson & Johnson. Equitable relief has always been allowed against state entities. So right there, that should end the discussion. We pled abatement, but we did so much more. We asked for the equitable remedy of accounting, the equitable remedy of disgorgement. We asked for declarations as a part of our abatement plan. And I want to be real clear, we didn't ask for a declaratory judgment. we asked for declarations as a part of our abatement plan. And those are very important to the Greenwood community and these particular survivors, because you have defendants who've never, ever been held legally responsible for the massacre. And to this very day, these defendants deny that they perpetrated the massacre. They deny that they created a public nuisance. They deny that they have any legal responsibility to clean up the public nuisance, the blighted neighborhood of Greenwood that they created. And as this court has stated, it is really up to the district courts to decide the declarations that we need in this case to move this case forward. And I will cite to you a case called Conoco Inc. versus State Department of Health, where this court stated in 1982, quote, whether a court should grant declaratory relief is not a question of power or jurisdiction of the court to grant relief, but the appropriateness of that particular procedure or remedy for the particular justiciable controversy. And that gets me right to the issue where the defendants have argued that this case is not justiciable, that this is some kind of public policy. We're asking this court to step into the shoes of the legislative executive branch, but that's simply not true. As this court has stated in an application of State Ex Rel Department of Transportation, for a claim to be justiciable, this court has held the claim must be definite and concrete. Parties must have an adverse interest, and it must be right for a decision granting or denying specific relief of a conclusive nature. Obviously, there's a definite and concrete controversy here, and there are adverse parties. On one side, you have the 109-year-old last two living survivors of the Tulsa race massacre, and on the other side, you have the perpetrators of the massacre who has escaped any liability for 103 years, who deny that they caused the massacre, deny that they caused the destruction that these survivors actually witnessed with their own eyes. That is a definite controversy, and there's adverse legal interest, and it's ripe for a decision granting or denying specific relief. And in this state of Oklahoma, district courts have the authority and the power to adjudicate these type of property-based public nuisance claims between private parties. First, we'll look at Oklahoma Constitution, Article 7, Section A, for the original jurisdiction that gives these courts, the district courts, the power to hear these cases. But then we look at a case called Smeckless versus Spitz, which is a 1992 case that Justice Colgar actually wrote for the court. And that case is very instructive in this particular case that we're talking about today. Because in Smeckless versus Spitz, you had a defendant who was polluting a river in the city of Norman. It was causing so much problems that the city of Norman itself passed a resolution or ordinance calling what that defendant was doing was actually a public nuisance. But when the plaintiffs went to court, this court said that that was not enough. It was not enough that the city had said it was actually a nuisance. A district court had to decide, pursuant to 50 OS 10, was that private citizen, that plaintiff, specifically injured to be able to bring the public nuisance case. That meant that the district court has the authority and the duty to look at a public nuisance when you have private parties, as these two survivors are, and see if they're specially injured and to see if that case can move forward. Then we go back to our Mendes versus Johnson case. Remember, Mendes versus Johnson was the oil case that I talked about earlier, where you had an 80-year-old oil issue that was brought up into a claim in 2006. In that particular case, the defendants argued to the court that they were not responsible for the public nuisance because they didn't own the land when they first started pumping oil. Well, the court knocked that down. But then the defendant said, well, the district court does not have the authority to order abatement because the Oklahoma Corporation Commission has exclusive authority to clean up oil and gas pollution. And in the Minders case, again, Court of Appeals, not binding on this court, but they specifically analyzed this issue of original jurisdiction by the district courts and the nuisance statute itself. And they came back and said, no, just because another branch of government may have concurrent jurisdiction or may have some dealings with a particular public nuisance issue, it does not eradicate or eliminate the district court's ability to look at the case and make a determination. That's what we're asking for here. We have two clients who are specifically injured by the massacre. There are only two people in the whole world of 7-8 billion people that are here. They had the special injury. They're asking for this court to allow the district court to make the factual findings that's necessary so we can move this case forward. I would also make the court point very clear. Again, we have not, even though this case has been litigated now since September 1, 2020, almost 3.5 years, we have not had opportunity to do any discovery. This is a pleading case. And if this court takes our pleadings and takes everything as true as you're required to do, we have set forth a public nuisance claim, and we have set forth adequate remedies for the public nuisance. In this case, it's not about public policy issues. This is a localized, discrete neighborhood of Greenwood. One neighborhood and one city here in Oklahoma. We fit exactly within the public nuisance statute and exactly what this court said in Johnson & Johnson. Next, I want to be very clear that the GTCA does not apply in this case. Yes, Justice Rowe.
Before you move on, I want to talk about the public nuisance action. Johnson & Johnson was an action brought by the state of Oklahoma, correct?
Yes, sir. Yes, Your Honor.
And public nuisance actions are typically brought by public officials, not private individuals. And in order for a private individual to bring a public nuisance action, it must be shown that the individual has a special injury different from that suffered by others. And here we had a large number of victims. How are these plaintiffs' injuries different in kind or special from the other victims of this event, this massacre?
Thank you, Justice Rowe. These particular plaintiffs, who are both 109 years old, are the only two living survivors of the massacre. And so no one else in the world has the injuries that they have today. That's number one. Number two, this court has said that special injury, in your case, McKay versus City of Enid, is a 1910 case. The special injury to mean a harm that is different in kind from the public at large. It doesn't mean necessarily that some other people may not share the injury or the damage. But again, there's no one else in the world that shares this injury because they're the only two that's still living today.
But doesn't your petition allege that the plaintiffs bring this action on behalf of other victims of the nuisance?
Yes, because that's exactly what we have to under 50 OST, and they get to step into the shoes of the community. And so I would also say that underneath our pleading standard, I'm sorry, go ahead. No, underneath the pleading standards, we specifically pled that the public nuisance is causing our clients and the Greenwood community. It annoys and injures the survivors' comfort, repose, health, and renders survivors insecure in their life. That's what we pled. That is our burden at this point in the litigation. Again, this is a pleading stage. That's all we have to allege to have an opportunity to move to discovery and then prove our claims. And that's what we want to do. We believe we can prove all the claims that we put in our petition. We just have not had the opportunity yet. So as I was saying about public GTCA, it does not apply in this particular case, the Tort Claims Act. First of all, the chamber is not a public entity. It is a private entity. So any arguments about GTCA does not apply to the chamber whatsoever. But in Johnson & Johnson again, Justice Winchester again writing for the court, said, quote, an action for abatement of a nuisance is equitable in nature. And since statehood, since 1907, equitable relief has been allowed against state entities. We cited several cases in our briefs. There's three I would like to highlight. First is Mark Watt versus City of Guthrie. This is a 1907 case where this court held that abatement could be held, public injunction relief could go against the City of Guthrie. 1942 case we cited, Finlads versus Oklahoma City. It's a 1942 case. What's very interesting about that case is that the plaintiff brought action for injunctive relief and equitable relief, and monetary damages. But this court dismissed the monetary damages before sovereign immunity, but allowed the equitable relief to move forward. We cited a case from 1981, Gay Student Alliance versus Oklahoma Board of Regents, 1981 case. Also, those plaintiffs were asking for monetary damage and equitable relief. Again, this court dismissed the monetary damages portion of the case because of sovereign immunity, but allowed equitable relief to move forward. Because equitable relief is different than monetary damages. And if you think about it, since 1907, plaintiffs in Oklahoma have been able to hold state institutions liable for equitable damages. And then you get to 1985, the GTCA in Vanderpool, your case in Vanderpool in the early 80s, allowed plaintiffs to also hold state officials, not just for injunctive relief, but now monetary relief. So it didn't create the right for injunctive relief in 1985. It created the right for monetary damages. And we're not asking for monetary damages in this particular case. And as I stated earlier, we've been litigating this case for almost 3.5 years. And in that time, the defendants have not been able to produce one case that supports their position that equitable relief is implicated by the GTCA. Not one case, and not just one case in Oklahoma. They have not been able to produce one case throughout the entire nation. While we were able to provide the court with several cases throughout the nation where very similar GTCA acts, tort claim acts, specifically say that public nuisance asking for abatement or equitable remedies is not impacted by the GTCA. Also, Your Honors, if you look at the plain language of the GTCA statute itself, it specifically covers only monetary damages. If you look at 51 OS 153A, it says, quote, the state or political subdivision shall be liable for losses resulting from its torts or the torts of its employees if a private person or entity will be liable for money damages under the laws of this state. If you look at 51 OS 152.4, which is the definition of what is a claim under the Oklahoma GTCA, it says a claim is, quote, any written demand presented in accordance with this act to recover money from the state or political subdivision as computation. Those two areas of the GTCA alone evidences the clear intent for the legislature not to restrict or not to require equitable relief to go through the GTCA. It is only talking about monetary damages. And in fact, one of the cases that we cited, Scholar versus State Department of Public Safety, which is the 1995 case, Justice Carter actually concurred in that particular case. In that case, this court forced the Department of Safety to give money back to citizens in Oklahoma, and that money was not considered compensation. Just to dive into that a little bit more, what happened in the Scholar case, the Department of Justice received excess reinstatement fees for driver's licenses that had been suspended. And when those plaintiffs actually sued the Department of Justice to receive their money back, the Department of Justice said, no, the GTCA prevents this lawsuit. But this court specifically stated that the appellees in that case are not seeking compensation, whether they're seeking a refund of unauthorized reinstatement fees collected by DPS. That's the same type of a rationale here. We're not asking for compensation. We're not asking for monetary damages. We're asking for equitable relief. In the Scholar case, that was an equitable relief for disgorgement, which is one of the things that we've asked for. I think also if we look at Johnson & Johnson, public nuisance is not a GTCA tort. You know, Justice King made it clear that this court has never held that the public nuisance is a tort, when in her concurrence in Johnson & Johnson, paragraph 1, Justice King wrote, quote, I write to discuss why Oklahoma's nuisance law is not, and unless the legislature amends it, never will be a tort. And the legislature has not amended the actual the GTCA since the Johnson & Johnson decision. If you look further, again, if we're looking at the plain language of the GTCA, it defines a tort as a loss to any person, association, or corporation. That's 51 OS 152.17. But it does not say a loss to a neighborhood or a community. And that's exactly what the public nuisance statute says at 50 OS 2. And that is what our claim is, a claim for a loss to the neighborhood or community of Greenwood. The defendants are wanting you to put language in the GTCA that is simply not there. In fact, this court in Barrios, a case you looked at in 2018, you looked at the actual definition of tort in the GTCA. And in Barrios, that's Barrios versus Haskell City Public Facilities, 2018 case. The court, the city of Haskell was arguing that the new definition of tort made any wrong that happened in the state of Oklahoma will fall under basically the GTCA against a public entity. This court said no. This court said no. The Tort Claim Act only talks about constitutional losses that require monetary damage or compensation. I think, and then if you think about the cases since burials, since 2019, the district court in Oklahoma, in Tulsa, federal district judge, Judge Gregory Frizzell, in a case called Fincher versus Singler, he held, quote, the GTCA reflects a concern regarding the imposition of money damages against the state and is inapplicable to suits seeking only equitable relief. And just last year in a case called Thomas versus Stitt, here in the Western District, right? Yes.
You're about out of time. I want to ask you, if I can, about your unjust enrichment claim.
Yes.
On your unjust enrichment claim, what is the equitable relief you're seeking? Are you seeking money held by the defendants?
Yes, disgorgement. We're seeking disgorgement. If we're in discovery, we're able to prove that the defendants received unjustly money, that we believe that they utilized the survivors' stories, we're seeking the equitable remedy of disgorgement, which is exactly what happened in Shola.
But the money you seek is money, I take based upon your statement, money into the hands of the defendant from third parties, not from the plaintiffs directly.
It was not money from the plaintiffs directly, that's correct.
Is that not a requirement of unjust enrichment, that the defendants hold money that's directly owed to the plaintiffs?
Well,
and how do you show that?
I think in this court's case, Fault versus Blair, 2010 OK 16, which is a decision that Justice Edmondson wrote, the 4 elements this court has laid out for unjust enrichment is the unjust retention of a benefit received at the expense of another. And I think this is such a great case of that, as we played it in our actual petition, that the actual perpetrators of the massacre utilized the survivors of the massacre stories to benefit themselves. And again, this is a pleading case. We have not had a chance to prove it. We think we can. And we're hoping this court will give us the opportunity to prove our case, reverse this decision by Judge Wall, send us back to and remand it back for discovery to start as soon as possible. And we want these survivors to see justice in a lifetime. I see that my time is up, and I'm happy to answer any questions.
Yeah. Counsel, these 2 individuals that are in the courtroom today, is it your position that they are the only 2 individuals that could bring the case?
No, Your Honor. We think because we've alleged an ongoing public nuisance that's ongoing, that anyone within the Greenwood community that's suffering from that blighted community and their health, safety, and welfare is annoyed pursuant to the statute, that they could bring that particular case. But we think these 2 individuals are obviously those who we want to see justice in their particular lifetime. Thank you for the question.
Yeah, I have a question. I'd like you to speak to the, you are alleging that there was a stipulation that was violated when the later motion to dismiss was presented. Can you speak to that a little bit?
Yes, sir, Justice Gang. Thank you for the question. It is our position that during our hearing in May 2nd, 2022, there was a stipulation between the parties that if we made certain amendments to our unjust enrichment claim, that our understanding was the defendants would not file another motion to dismiss on that particular claim because they agreed we could cure the problem. And that's what our understanding was. And I think if you look at the record, I believe Justice Wall on an open court basically said she kind of understood that was the agreement also. The defendant said that was not their understanding. They filed different motions, and now, we're here today. And, we don't really understand why the unjust enrichment case was dismissed. There was no discussion about it in any of the orders that Judge Wall, either her August 3rd, 2022 order, or her July 7th, 2023 order, or her July 12th, 2023 order.
Well, let me talk a little bit about what Judge Wall did, because I need a little help with that too. Yeah, you're right on the timeline. On August 3 of 22, she made her first order on the defendant's motion to dismiss. And then the next year, she made a 1-page order on July 7 that granted a dismissal, and it was said based on what was set forth in the defendant's brief, if I recall correctly. And then about 5 days later, on July 12, there's what's now called the final order of dismissal with prejudice, and she dismisses, but then incorporates by reference the earlier order she'd made back in August of the prior year. And on page 6 of that order, Judge Wall says, applying Oklahoma's liberal pleading standard, the court cannot find beyond any doubt that plaintiffs Randall Fletcher and Van Ellis Sr. can prove no set of facts which would entitle plaintiffs to relief on their public nuisance claims, which seems to militate towards saying that she was not dismissing that. So what do you make all that?
I totally agree with you, Chief Justice, and I think it goes exactly what, in the case McGee versus El Patio that I discussed earlier, where you stated that a motion cannot be granted if there is no set of facts that we can prove. And she actually stated that on August 3rd. So we're completely surprised and just couldn't believe that the case had been dismissed based upon the August 3rd, 2022 order.
Counsel, it seems to me that you're more interested in what's happening now, the failure to abate, to let the public nuisance exist as a result of the massacre, but you really can't go back to the massacre. Is that right? Really, it's what's happening now is what you're complaining about.
Yes, we're saying, as Justice Carter, thank you for the question. There's an ongoing public nuisance that started because of the massacre. That is what we've alleged.
Thank you.
All right, thank you, counsel. We appreciate that.
Thank you, Chief Justice.
And we'll see you again here in a few minutes. So now appellee Oklahoma Military Department will now be allotted 10 minutes to present their case. During this time, justices may ask questions as points are presented. Appellee's counsel Gary Gaskins is recognized.
Thank you, Mr. Chief Justice, Mr. Vice Chief Justice, and may it please the court. The Oklahoma Attorney General's Office represents the Oklahoma Military Department in this matter, which is the administrative arm of the Oklahoma National Guard. But most of the arguments I'm going to make today apply equally to the other governmental entities that have been sued. And except for the sovereign immunity arguments, the remaining arguments I'm going to make today apply to the Tulsa Regional Chamber. Before I begin, I think it is important to recognize the horrible injustices that occurred in Tulsa on May 31 and June 1, 1921. The death and destruction that occurred on those days is certainly unconscionable, and none of the arguments being made today are intended to diminish or minimize those horrific events. I also want to note that we are here today in a court of law, not a legislative body. I think we all agree that this court is limited to interpreting and applying the law as it currently exists. It's not this court's role to legislate new laws or programs to alleviate historic injustices that occurred over a century ago. And as to this specific case, it is important to point out, quote, that this court is not bound by the trial court's reasoning and may affirm the judgment below on different legal rationale. And there are numerous defects in the second amended petition that warrant dismissal. Plaintiff's claims are barred, 1, by common law sovereign immunity. 2, the fact that intentional torts are generally outside the scope of employment. 3, latches. 4, the fact that plaintiffs have not identified a violation of a public right sufficient to state a claim for public nuisance. And 6, the Governmental Tort Claims Act. By 10 minutes, I won't have time to thoroughly address each one, but I do invite questions from this court on any of these issues. First, plaintiffs' claims against the governmental entities are obviously precluded by sovereign immunity. As of 1921, when the Tulsa race massacre occurred, there was no Governmental Tort Claims Act or any statutory mechanism to waive sovereign immunity. In 1958, this court said, quote, "It is fundamental that the state cannot be sued in any manner or upon any liability, constitutional, statutory, or contractual, unless there is express consent thereto. On the issue of an injunction, in 1925, this court in Choctaw Press Brick Company v. Townsend said, the state cannot be enjoined. So all of the allegations against the Oklahoma Military Department predate the abrogation of sovereign immunity by this court in the Vanderpool case and the Oklahoma legislature. And the Governmental Tort Claims Act did not become effective until October 1, 1985. Likewise, common law sovereign immunity was not abrogated for cities until 1978 and counties until 1979. So as of 1921, when the massacre occurred, all of the governmental entities that have been sued were protected from liability under the doctrine of sovereign immunity. And therefore, there are no possible grounds for recovery against the governmental entities for acts that occurred during the Tulsa race massacre. Next, the National Guard members were clearly acting outside the scope of their authority if they were committing criminal acts. In fact, in the second amended petition, plaintiffs allege that the National Guard members violated the instructions of the governor to protect Greenwood residents and restore order. Plaintiffs are also seeking a declaration that the actions of the National Guard were inconsistent with their charter. As a result, plaintiffs have essentially asserted that National Guard members were acting outside the scope of their authority during the massacre. And during the argument today, the plaintiff's counsel referenced multiple crimes that occurred. By definition, a state employee that is violating the laws of the state and committing a crime is not acting within their scope of their employment with the state. So thus, in addition to sovereign immunity, under the basic rules of agency law, the doctrine of respondeat superior, the state is not liable for the criminal acts committed by National Guard members during the massacre. Plaintiffs have also not identified a public right that has been violated. In the Johnson & Johnson case, this court said, quote, a public nuisance involves a violation of a public right. A public right is more than an aggregate of private rights by a large number of injured people. Rather, a public right is a right to public good, such as an indivisible resource shared by the public at large, like air, water, or public rights of way. Here, the destruction of buildings, homes, and businesses are certainly unconscionable and tragic, but they are technically an aggregate of private rights. And while a large number of people may have been injured during the Tulsa race massacre, the destruction of the buildings, homes, and businesses does not meet the definition of a public good, such as air, water, or public rights of way. Therefore, plaintiffs have not identified a public nuisance. I'd also point the court's attention to 50 OS Section 4, which says nothing which is done or maintained under the express authority of a statute can be deemed a nuisance. Here, the National Guard was called to Tulsa during the massacre pursuant to an order declaring martial law. The order calling the National Guard to Tulsa and the order declaring martial law were both expressly authorized by statute. I believe those orders were attached to the pleadings to the state court, district court. So it's clear that the National Guard members were called there pursuant to statute. As a result, by the very definition of public nuisance, it can't be a public nuisance. Plaintiff's claims are also not redressable, which is one of the essential elements of standing. The requirement of redressability essentially means that each litigant must present a claim that is judicially fixable. And in Johnson & Johnson, this court indicated that it is inappropriate for it to, quote, step into the shoes of the legislature by creating and funding government programs designed to address social and health issues. Public policy matters, quote, should be dealt with by the legislative and executive branches, the branches more capable to balance the competing interests at play in societal problems. Here, plaintiffs have asked for businesses to be replaced, as well as the return of land to the Black community. To accomplish this, the court would have to order the legislature to come up with some mechanism to confiscate land.
Counsel, we're here on a pleadings case.
Sure.
You're talking about a lot of evidence and a lot of other things that, as I understand it, there's never been any discovery. So this is a pleadings case. So I hope you would stick to that.
Sure, I understand. I mean, of course, sovereign immunity is something that's apparent on the face, and plaintiffs. This is a heightened pleading here. Plaintiffs have to show that they have been specially injured to even have standing. So, yeah, regressibility is one of the three essential elements of establishing standing, and they have to show that what they're complaining of is actually redressable to come into court, and they have just not done that, consistent with Johnson & Johnson.
Well, tell me, Mr. Solicitor General,
Yes.
your take on the three-part order of Judge Wall that I asked about a moment ago.
Well, I think the most important part of Judge Wall's order is the case was dismissed. And so that means we're here on a de novo review. And as I pointed out at the beginning, this court is not bound by the trial court's reasoning and may affirm the judgment below on different legal rationale. So to me, the important part is she dismissed the case. And as a result, we're here on a de novo review, and this court isn't bound by whatever findings Judge Wall made that are ancillary to dismissing the case. Say it again.
Are you suggesting that she ruled erroneously, but there's another way that we can uphold her?
I'm not saying that she ruled erroneously. I think the judge was talking about redressability is how I read the order, is that there wasn't a remedy that the court could issue, which is one of the three essential elements of
Well, you're
standing.
implying that her ruling was sound only in its result.
I'm not saying that it's sound just in the result. I mean, certainly, I think the court was correct to dismiss the case, and I think there are a lot easier ways to dismiss the case, such as the sovereign immunity and some of the other things that I've mentioned today, and latches, which I haven't talked about. So there are a lot of easier ways to dismiss the case, but I do think the district court was right to say that there wasn't an available remedy, because that goes to redressability.
Well, frankly, I share your confusion as to exactly why she dismissed the case.
And I understand it, but I think since we are here on a dismissal, it is de novo review. I think it works both ways. This court is not required to give that any special deference.
Well, if you can fathom it better than I, I'd appreciate the explanation.
And you brought up latches. Plaintiffs tell us that latches does not apply. Why do you suggest that it does?
Well, I think the latches applies because it goes back to, the latches cases that plaintiff has relied on in the brief are based upon 50 OS Section 7, which says that no lapse of time can legalize a public nuisance amounting to an actual obstruction of a public right. And again, as I just talked about a second ago, plaintiffs have not identified a public right, as this court has articulated in Johnson & Johnson, that is still being obstructed. So I don't think that 50 OS Section 7 actually applies in this situation. And the Rivard v. Hunt case that plaintiffs relied on, that was a case involving someone that put up a fence that was blocking a road. And 10 years later, someone sued to have the person take down the fence, and the court held that the fence didn't suddenly become legal because the person waited for 10 years. I think this situation is completely different, but regardless, we do not have an obstruction of a public right that has still been identified.
Any other questions from the court?
What's your position on the unjust enrichment claim and the proposed settlement
Right.
that the petitioners allege you all violated?
I do think that those questions are probably better for
Okay.
co-counsel. I don't believe the unjust enrichment claim was directed to the Oklahoma Military Department.
All right.
But I do believe Judge Wall did address that there did not find that there was this agreement on the unjust enrichment. But I think those questions are better left for my co-counsel.
Were you present at that time?
I was not.
All right, thank you.
Counsel for the plaintiff said that this is an ongoing nuisance.
Right, I've heard that. So one, we haven't identified a public right that would even justify a nuisance. They haven't
What
identified,
about the public right to a clean and safe neighborhood?
right? So then I think this, I was about to get to, this also gets into the fact that plaintiffs have to show that they've been specially injured. In addition to,
How can there be any question that these plaintiffs have not been specially injured? I mean, did the military attack other neighborhoods in 1921?
sure. I think that we're here. So one, I think we have to step back and go to common law sovereign immunity, right? In 1921, there was no mechanism to waive sovereign immunity. And I think this court made clear in the Vanderpool case and the Oklahoma Governmental Tort Claims Act makes clear that it only applies to claims that accrued after October 1, 1985. And in Wallace v. Cato from the U.S. Supreme Court, it said that accrual occurs when the plaintiff has a complete and present cause of action. Plaintiff did have a complete and present cause of action prior to October 1, 1985. So the fact that the suit wasn't brought previously is unfortunate, but it is still covered by the Governmental Tort Claims Act. Or not, it's still covered by common law sovereign immunity. The Governmental Tort Claims Act provides another defense, but we don't even have to get there.
All right, thank you very much, Counselor.
Thank you.
Next, we will hear from Appellee Tulsa Regional Chamber, also allotted 10 minutes. Counsel will be John Tucker.
Mr. Chief Justice, members of the court, may it please the court. I am John Tucker here with Colin Tucker on behalf of the Tulsa Regional Chamber. I will present two issues in response to the appellant's argument and brief filed in this court. And I hope perhaps help explain why Judge Wall dismissed this case, as apparently our briefs failed to make that persuasive point, at least to Justice Edmondson. I will present two issues. First, appellant's second amended petition does not state a cause of action for which a court can grant relief, an important point, as established by the opinion of this court in the Johnson & Johnson versus Oklahoma case. And second, even if the second amended petition stated a valid claim of public nuisance, these individual plaintiffs lack standing to bring a claim for public nuisance. The appellants described to you what the continuing nuisance that is going on today in detail in their petition, to less detail in their brief, but today, counsel for appellant stated that there are 1,500 properties.
Mr. Tucker, it's very difficult to hear you.
I'm sorry,
That's
Your Honor.
much better. Thank you.
It's the feedback from my hearing aid, a consequence of technology. I apologize. The appellant told us today that there are 1,500 properties that need to be given back to their rightful owners. That's part of what they see. That Greenwood is still blighted and that needs to be corrected, that's the nuisance. Keep that in mind as we proceed. These issues are all plainly describing issues of inequality, discrimination, economic disadvantage, and related issues. But they are not nuisance as they relate to these plaintiffs. In Johnson & Johnson, this court gave clear direction as to what Oklahoma nuisance law is not. The court rejected in multiple places the concepts of expansion of the traditional meaning of nuisance to remedy societal ills. And the acts of Johnson & Johnson were found to have caused societal ills. That's what that lawsuit was about. That was not referenced by the Solicitor General, and that is that This court defers the policymaking to the legislative and executive branch and rejects the unprecedented expansion of public nuisance law, which is what Judge Balkman did in Cleveland County in the Johnson & Johnson case. The appellants here ask this court to either ignore or just plain disregard, or, as they put it, take our view of the case and it supports exactly what we want. We believe that's a misreading of Johnson & Johnson. It's fair to say that under the provisions of the decision, J&J, the petition, taken as true, does not pass the test. What Johnson & Johnson made clear to litigants was that efforts by district courts to expand our nuisance statute into something it is not and has never been is simply not allowed. The court held that public nuisance is to address discrete, localized problems, not policy problems, and that to erase the traditional limits on nuisance liability would make the Oklahoma nuisance statute impermissibly vague. The court said it would result in allowing courts to manage public policy matters that should be dealt, in fact, by legislative and executive branches. The court said if a judicial remedy cannot cause the alleged nuisance to cease, the claim must be rejected. Now, Judge Wall, I suppose, then would be supposed, under the plaintiff's view, to order the identified 1,500 properties to identify the rightful owners and return it to them. Judge Wall would have to enter an order that the blight had to go away from North Tulsa. Those are things that would perhaps be good to happen, but it's not for a district judge to take control of all those social issues and direct that they be fixed. And what are the appellants alleging, if not that this court is being requested to allow a society-wide order of abatement to address social issues, health issues, criminal issues arising from a conduct that they say is a nuisance, a conduct which they have yet to identify is ongoing. What they have identified is consequences that they say result and continue to exist as a consequence of acts in 1921. As plaintiffs say in their prayer for relief at page 50 of their amended petition, they want an order to abate the harm defendants caused by other things, replacing buildings, homes, and businesses destroyed during the massacre and returning misappropriated land to the Black community. Number 6, an order requiring the abatement of public nuisance by defendants, including the abatement of all the conditions in the Greenwood neighborhood that are aspects of the nuisance created, including but not limited to restoring property, removing impediments that continue to injure the comfort, repose, health, and safety of Greenwood. Those are simply things that a district court can't do.
Does the city of Tulsa own any property in this area?
I have no idea, Your Honor.
That's because there's been no discovery?
Well, I think it doesn't really matter if the city of Tulsa owns the property, because the city of Tulsa would not have been who took the property. All of these are facts that aren't in the record. The property the city of Tulsa owns is as a consequence of the federal government's urban renewal program. So the federal government's not a defendant here, but I suppose they'd be a participant in the nuisance as they're maintaining these today. Appellants say that they only have to say that they want abatement. They don't have to show why or what it means. The appellants overlook the basic principle that to avoid mootness, there must be some abatement remedy that'll work. None has been suggested. Everything that's been suggested or everything that's required are things that cure societal ills, and none specifically apply to either of these individual plaintiffs.
Counsel, is the Tulsa Chamber, you represent the Tulsa Chamber?
Yes, Your Honor.
Is your client involved in any museum or anything in the neighborhood to educate the public about this massacre?
No, Your Honor. The Chamber of Commerce is there to provide assistance, support. It's not a funding agency. It is a voluntary association.
Are there activities ongoing in the neighborhood along the lines I've questioned?
Well, yes, there have been a lot of civic activities. Several individual groups in the Greenwood community, which do not necessarily get along with this group, are behind for example, the Race Massacre Museum, the creation of the walk in Black Wall Street to commemorate Black Wall Street and the restoration of the area. Those are efforts obviously the Chamber of Commerce supports, but they aren't the Chamber's efforts.
Are they involved with any of the defendants?
The Chamber would like to say that if there's anything that's good about the community in Tulsa, they'd like to be involved in it. But the extent of it, I don't know.
Was the chamber in existence in 1921?
Yes and no, Your Honor. The current Chamber of Commerce is the third corporate entity that represents the community of Tulsa. Chamber of Commerce has historically always publicly adopted the positions of the previous chambers as a matter of continuity in support of civic spirit in Tulsa. Technically, no. As a practical matter, they have taken the position that they are a continuity. The second point I wanted to make is why appellants lack standing to bring this claim. As the court pointed out, they must show that this is especially injurious to them in a manner greater than others that may be affected by the same thing. Several cases have described that. At page 5 of the plaintiff's second amended petition, they start to identify the special injuries to the plaintiffs. Mother Randall, one or some of the defendants looted and destroyed Mother Randall's home, rendering her insecure in her sense of safety in the aftermath of the massacre, and caused her to have emotional and physical distress that continues to this day. Goes on to describe the distress. Same was said for the other parties. Oklahoma has felt that these things do not satisfy the claim because some personal injury or property damage, however slight, must accompany these claims for mental anguish in order to recover. Appellants simply failed to argue that there was any special injury to them beyond those sustained by others who were present for the 1921 massacre, or as this court observed, by others who came later who may be affected by the economic disparities that may have followed from the massacre. This court wants to expand public nuisance law. The appellants want this court to expand public nuisance law, even though that would require management of public policy by the district court. In Johnson & Johnson, you said you don't minimize the severity of the harm that people suffered as a result of opioids. However grave the problem of opioid addiction is in Oklahoma, public nuisance law does not provide a remedy for this harm.
Okay, and I appreciate that, Mr. Tucker. We've exceeded our 10 minutes by just a few seconds, but the court may have some additional questions for you. Please stand by for a moment. We'll see if anybody has any other
Yes, Your Honor.
questions.
Chief, were you involved in this proposed settlement discussion?
Yes, Mr. Justice. I was in the courtroom and I heard it all.
What's your recollection? Was there an agreement not to object to the amended petition on the claim of unjust enrichment?
There were, during the course of the argument on the failure of the allegations, one of the plaintiff's counsel said if we take out paragraphs, I think it was K through Y, then that would remove all those complaints. So an agreement was reached that if those allegations were removed in an amended petition, that there would be no further briefing filed by the defendants on the point of unjust enrichment. When the plaintiff refiled its petition, they took out those paragraphs, but they added many more. Consequently, a motion to dismiss was filed because the new petition said much more than the other petition had said. As a practical matter, I observe if you look at the order of the judge, the dismissal of unjust enrichment claim was without prejudice, and the plaintiffs chose to come here on their appeal rather than refiling the petition as authorized by the district court. Just as the Chief Justice observed in her order of 2022, she found that I can't say that there's no set of facts these folks can't present that would show an abatement was a remedy they like an order. And in that order of 2022, she authorized the filing of an amended petition. And the amended petition that was filed, the second amended petition, is the one that was dismissed with prejudice, and that's the one we're here on today. I'll admit the paperwork that she did is not the clearest, but that's what happened.
Thank you.
Thank you.
Let me follow up, but before you get away, Mr. Tucker, I have a follow-up on that.
Yes, Mr. Chief Justice.
So the suggestion from the plaintiffs that there was a promise from the defendants that a new motion to dismiss wouldn't be filed, would that promise be reflected in the transcribed record of the trial court?
It would, yes.
And so the record would speak for itself there on what the parties stated.
That's correct.
Thank you.
Thank you, sir.
All right, let me get back to my list of who comes next. I'm doing a bad job of keeping my papers unshuffled here. There we go. All right, we will now allot 10 minutes to the city of Tulsa, and counsel for the city, I'm told, will be Christina Gray.
For clarification, I had asked for 5 minutes, if that helps the confusion on that issue.
Five it is. My sheet was in error. Just so I can make sure, I do show the sheriff, Tulsa County and the sheriff are allotted 5. Is that accurate? Okay, and then I show a rebuttal of 5. Is that what plaintiffs were expecting? Yes. Okay, so I only had 1 that was an error. Very good. You may proceed. Thank you.
Thank you, Chief Justice, and may it please the court. My name is Christina Gray. I'm the litigation manager with the city of Tulsa. And obviously I would accept questions on any issue, but I specifically had planned to address 2 issues. One of which being the questions that Justice Holm raises several times about the agreement, about the waiver of the unjust enrichment, as I was actively involved in that discussion. The second point of interest that I will get to, assuming that I have some time, is the issue of latches. So I will start because there's been some very specific interest about what agreement was made on the record and how that came about with that specific issue. In the September 28th, 2021 hearing before the district court, each of the defendant attorneys presented different topics. I presented the argument on latches and brought up the issue that one of the issues in the plaintiff's complaint was asking for disgorgement of funds over a period of 10 or over 100 years. When I brought up that point and issued that should be barred by latches, the plaintiff's counsel said, no, we didn't intend to ask for 100 years of disgorgement. We meant to ask for 2 years of disgorgement because there's a statute of limitations on unjust enrichment. So there's discussion on the record, which is reflected in the record that's part of this appellate record in the transcript, wherein the plaintiff's counsel said, in order to fix that pleading error, we will take out those to address the latches issue. Nothing was done at that time. No amendment was made and no agreement was done. We came back in front of the district court on May 2nd of 2022 and had an additional oral argument where the district judge asked, what about this agreement to file an amendment? In the record on this case, it's document 50, volume 5, page 86, is where the supposed agreement is reflected. And essentially the discussion between counsel was that to fix basically a small pleading error would then, as this court's well aware, an amended petition would undo all of the briefing and argument that had happened. There had been substantial briefing, there had been substantial oral argument. So what the record reflects is that the argument is, if this is all they fix, it specifically says that will be the only purpose of the amendment is to take out subparagraphs A through N, then the defendants will, quote, rest on the existing motions to dismiss with respect to their legal arguments. There was no waiver of any of the issues which we have raised. It was we will rest on our motions to help this proceeding move forward and not have to redo what we just did because of a technical pleading error. So at that point, we rested on the motions. Now that technical pleading correction didn't happen because what happened in the May 2nd, 2022 hearing is at the end of the hearing, the district judge from the bench issued a partial ruling of granted in part, denied in part, and then we waited for the written order. So that technical amendment where this supposed agreement happened never actually occurred. Then on August 3rd, 2022, we received the district court's written order that allowed the plaintiffs to amend. And at that point, when they provided a full amendment which addressed public nuisance and unjust enrichment, the parties re-urged the substantive arguments with respect to the unjust enrichment. So that's the issue with respect to whether there had been some settlement or agreement. Again, it's clearly in the record that the parties stood on the existing motions in light of this very minimal adjustment that was going to be made that ultimately wasn't made because of the court's ruling in the agreement. And with that, the other argument that I would like to address before this court in my limited time is the issue of latches. I believe that the Solicitor General addressed it quite a bit, but I would like to go back to the argument that Plaintiffs' Counsel has said today that for 130 years, there's been the law that public nuisance is an available remedy. This is not a new remedy. This is not a new injury. This is something that happened as a result of an incident, a terrible incident in 1921, but it's something that has been delayed, and it's something that is prejudiced by the face of the complaint. This court has held relatively recently that if latches is determined by the face of the complaint, it's something that can warrant dismissal. In this case, we're talking about witnesses, we're talking about documents that existed or created 100 years ago. You heard the plaintiff today that these are the only 2 living survivors from the race massacre. So in order to try to obtain documents, information, and testimony, there is a prejudice that's identifiable from the face of the complaint. And with that, I believe I'm almost out of time, but I will accept any questions if there are any.
I do have a question about the procedure at trial. Where you talked about, you made reference to the document 50 and I looked, I saw some of the transcripts that were, well, not the language that apparently was pulled from transcripts in the briefing, but you're telling me that what was on the record and transcribed was the totality of any agreement counsel had. There were no additional emails or other documentation of this.
That's correct. There were no additional emails. Other than there was some discussion, the only thing that would not have been reflected on the record is there was some discussion from counsel before it was memorialized on the transcript in the hearing. But I am not aware of any other documentation other than what's memorialized in the transcript of that hearing.
Thank you.
Is it my understanding then that the judge, the last time that you were in front of the judge was before July of last year? We have the order of August 3rd, 2022, and then we have the 2 in July of 2023. How many times were you in court, and what day was it? May 2nd, 2022, when this agreement is reflected in the record?
I believe there was a hearing, one additional hearing after the August 3rd, 2022 order before the 2023. This supposed agreement was prior to the first order, the August 3rd. It was the agreement or statements on the record in the May 5th, 2022 oral argument. It's kind of initiated in that first September 28th discussion, but the memorialization of the record is made on the May 5th, 2022. I believe there was some discussion in front of the district court in the subsequent hearing after the second amended petition, but only as a matter of whether the court would consider that as something that had been addressed or waived. And I believe the court on the record said that she did not consider, that she would consider all arguments, that she did not consider it waived as far as for purposes of considering the second amended complaint. But I don't have a record citation in front of me. I apologize.
So does the city of Tulsa own property in Greenwood?
As of today, Your Honor, I don't know the answer to that question. Right.
Any other questions from a member of the court at this time?
Thank you for your time.
Thank you, Ms. Gray. All right, next we'll allot 5 minutes to the Tulsa County and Sheriff Regalado. Counsel will be Keith Wilkes.
Thank you. Mr. Chief Justice and Justices of the Oklahoma Supreme Court, may it please the court. I have to make sure my papers don't end up on the floor here. On behalf of Vic Regalado, who sued in his official capacity as sheriff of Tulsa County, and the Board of County Commissioners of Tulsa County, who all step into the shoes of their predecessors from over 100 years ago, thank you for retaining this important case. The Tulsa Race Massacre is indeed a dark moment in the history of Tulsa, in the history of our state, in the history of our country. 103 years later, none of us can comprehend the epic of fear, hate, distrust that fueled an angry mob of white men who left Greenwood and the surrounding community in ruins when the dust and the smoke settled. However, for the men and women who survived and stayed, the end of the massacre was also the beginning of another story. And it's a story that should not go unacknowledged, and it is important here in light of this ongoing public nuisance argument. In their briefing, chief, counsel for the appellants claimed Greenwood was never rebuilt after the Tulsa Race Massacre. While in line with their claims, this assertion is simply not supported by history. The court can take judicial notice of history, and then you can see Title 12, Section 2020, and also Farley v. City of Claremore, 2020, OK 30 at paragraph 13. We do not need an advocate's sharpened pen or an eraser to elaborate on or diminish the events that led up to, through, and after the race massacre. The story of the triumph that unfolded the decades that followed is there, and history stands on its own. Fortunately, we have the unquestioned work of respected historians John Hope Franklin and Scott Ellsworth, the primary historians and authors of the Tulsa Race Massacre Report, who pieced together the details leading to and through the dark days of the years that followed. It is Ellsworth who writes, "The rebuilding of Black Tulsa after the riot, particularly that of Deep Greenwood, is a story of almost as great importance as the riot itself. Perhaps more than anything else, this rebuilding was a testament to the courage and stamina of Tulsa's Black pioneers in their struggle for freedom." The Race Massacre Report itself, which is part of the record, states that after the massacre, quote, "the residents worked together and rebuilt. Not only did they rebuild, they again successfully ran their businesses, schooled their children, and worshiped in their magnificent churches." That's a Race Massacre Report at page 149. Juanita Alexander Lewis Hopkins was an adult witness and survivor of the massacre. She was also a civil rights activist and a journalist for the Oklahoma Eagle, which has been called the voice of Black Tulsa. That publication was founded on the heels of the race massacre in 1922. She observed, quote, "After the riot, Tulsa rebuilt from the ashes. In fact, the Greenwood district after the riot was even more impressive than before the riot. That is when Greenwood became known as the Black Wall Street of America." This is after the riot. As we know, cities and communities are not static. They're dynamic in nature. They change with the times and with the needs. Oklahoma Journalism Hall of Fame member wrote in his book, Tulsa, 1921, reporting a massacre, Randy Crable, that despite its rebirth by the 1970s, the old Greenwood was all but gone. It was reduced to a single block of urban renewal, migration, big box retailers, an interstate highway system, and the simple passage of time. History has indeed recorded both the despicable acts and conduct of 1921, but it has also recorded the resilient spirit and triumphs of the Greenwood community that rose from the ashes of the massacre in the years that followed. This goes to this ongoing public nuisance claim that's based upon a stance that's not supported by history, that this community was not rebuilt. The 10th Circuit Court of Appeals summarized it well in Alexander versus Oklahoma 20 years ago. In upholding the federal district court, both courts, below and at the circuit court level, acknowledged the tragedy of the Tulsa Race Massacre, but they are left with the conclusion that as a matter of law, no legal avenue exists through which plaintiffs can bring their claims. 20 years later, the law has not changed. The only thing that has changed is that we're now another 20 years removed from 1921. The court and other courts have cautioned that the tort of public nuisance is not to expand to become society's catch-all and cure-all cause of action that applies when all else fails. That is what has been attempted here. Public nuisance is not a tort, says plaintiff's counsel, and with respect to anyone who agrees, the Johnson & Johnson court recognized in paragraph 13 of its decision that the opposite has been true since the 16th century. I dug further to see that it was in 1537, during the reign of King Henry VIII, when two areas of law that had traditionally been only part of criminal turned into tort law, and the other being libel. And it was previously viewed as a crime, which has become per se tort.
Now,
That's
Ms. Wilkes,
also-
I've afforded you a little extra time because you needed a few minutes to go to organize after our timer started. But we have reached our 5 minutes. Let me see if the court has any questions of you. I don't
Thank you,
think so.
Mr. Chief Justice and Justices of the court.
Thank you, sir. We appreciate your participation. And Mr. Solomon Simmons, this is your client's case. This is your appeal, and you very rightly get the last word.
Thank you, Mr. Chief Justice, and may it please the court. I just want to be clear again, we are at the pleading stage. We heard a lot of testimony and facts that really shows, again, why we need discovery in this case. Justice Gerrich, we pled in our petition that the city of Tulsa and other defendants do own property in Greenwood, and we believe if we get a discovery, we'll be able to prove that. We pled that many of those properties are a result of takings of the massacre. We think if we get to discovery, we can prove that. We also pled the public rights in this case, as the statute states, that because of the blight in Greenwood that they created during the massacre and is continuing to this day, is inhibiting or causing harm to the health, safety, comfort, and repose of the survivors in the Greenwood community. That is our duty at the pleading stage. That's where we are. We've pled that, and this court, based on your own precedent, has to take everything we stated as true. And if it is true that they blighted property in Greenwood that is causing a public nuisance, that should give us enough to defeat a motion to dismiss. Regarding the common law sovereign immunity, again, I would just recap for the court. Since statehood, actually even before statehood, but since statehood, since 1907, the first case that we cited, Marquardt versus City of Guthrie, and we cited a string of cases going all the way up until today, equitable relief has always been allowed against state entities. The defendants are wanting this court to take away a right that citizens in Oklahoma have had for 117 years, the ability to hold our government accountable through equitable and declaratory relief. That is what they're asking this court to do today. And I don't think this court should do that, particularly if we have not had an opportunity to get the discovery. There was some dimension also of Johnson & Johnson. I want to remind the court, as I know the court knows, Johnson & Johnson came to this court after a 33-day trial with thousands of exhibits and dozens of witnesses to create a record for this court to then analyze, was it actually a public nuisance that could be abated? Thirdly, I want to touch on this unjust enrichment question. I want to be clear that at this stage, we believe we have properly pled an unjust enrichment and we should be able to move forward. But I want to just have clarity on the discussion, Justice Kane, that we did have with the defendants. First of all, there was discussions that were not on the record. That's number one. And as Christina Gray stated, we had an additional hearing after that discussion. It was October 18, 2022. It's on the record that's document 48. And if you go to page 20 of document 48, I'm going to read you what Judge Wall stated her understanding of the agreement was. This is Judge Wall. Quote, regarding the unjust enrichment claim, certainly I think if you read the court's order, you will see that from the court's point of view, it was a reasonable interpretation of the stipulation that if only the time frame of the claim was redacted, there would be no further motions to dismiss that one claim. That was my understanding. That's Judge Wall. She said, that was my understanding. I thought it was a real simple stipulation. Apparently I misunderstood the plaintiff, the defendant's intent. But again, it's recorded by transcript, and to the extent that the defendants have included in their motion to dismiss the plaintiff had the opportunity provided by Oklahoma law to respond in writing. So I think it's very clear that it was our understanding and the judge's understanding that we had an agreement that we were going to move forward on the unjust enrichment claims.
Let me ask you this. If in fact, the defendant said they were going to stand on their position and then change their position, and the trial court, having received their announcement previously, has now changed its opinion and said, I'm going to allow them to do that, would that be an abuse of discretion issue on appeal, or what would be the proper standard of review?
Well, we think that a actual agreement between parties should be held, that the parties should be held to it. And that's what we thought was going to happen. Now, again, we believe we've properly pled at this point to move forward without the agreement, but I just want to make the court know that we did have those discussions. That was our understanding to move this case forward.
All right, and I'd intended to allow you to use your last time uninterrupted, so I'm going to give you extra time if you needed to get your final thoughts in.
Thank you. Justice Rowe, I thought you might have a question.
I do. I want to begin by thanking you and all of the council and the plaintiffs for being here today and doing a very fine job. My question is simple. It's in your brief. You say that the $30 million Greenwood Rising History Center is being built, and I read it to think you're wanting that's part of the nuisance. Which of the defendants is building that?
Well, I wouldn't say it was part of the nuisance, part of the unjust enrichment claim. And at the time we wrote this petition, the defendants were all a part of an organization that was raising money to build that particular museum. It is our understanding, as we pled in our petition, that about $30 million was raised. And we don't know how much of that money is actually went into the museum, and how much of that, where is that money? And that's, again, speaks to why we need discovery on this particular case, so we can prove and show what actually occurred.
Are you objecting to the building of the center as part of your nuisance?
No, we're not. We're not objecting to the building as a part of this particular litigation.
Thank you.
Any other questions?
No, but I have a statement.
Yes, Your Honor.
When I went to high school, I knew about the Trail of Tears. I knew why Chief Pleasant Porter wanted prohibition in the Constitution, but Greenwood was never mentioned. And so I think regardless of what happens, that you're all to be commended for making sure that that will never happen again, that it will be in the history books.
Thank you. Thank you, Justice Carter. I would just like to say two other things real quickly. One, as we pled in our petition, over a third of the homes and businesses destroyed during the massacre were never rebuilt, and many of those people were never heard from again. 8,000 people were made homeless overnight. And I want to say one last thing. 117 years ago, the founders of the great state of Oklahoma wrote these powerful words in the Constitution in Article 2, Section 6. Quote, "The courts of justice of this state shall be open to every person, and speedy and certain remedy afforded for every wrong and for every injury to person, property, or reputation. And right and justice shall be administered without sale, denial, delay, or prejudice." Yet these plaintiffs have been waiting for almost 103 years for their opportunity to be in court to prove what happened to them and their community. We're just simply asking that this court give us the opportunity to be remanded back to the district court to prove our claims. And if we have an opportunity at another time to discuss it after the trial, we look forward to that. Thank you.
Thank you, sir. Any further? All right, with that, the court will be in recess. Thank you all.
Thank you, Chief.